My name is Greta Milburn. I am 66 years old, and for 3 years, I drove to my daughter's house 5 mornings a week to care for my grandchildren, without pay, without a written agreement, and without once being asked whether that arrangement still suited me. The morning it changed was a Tuesday in late October, and I was at my kitchen counter sorting the recycling when my laptop chimed with an email notification from my son-in-law. The subject line read, FWD, Notes from Consultation, Guardianship Timeline and Next Steps. He had meant to send it to my daughter. Her email address begins with the letter L, followed by her name. Mine begins with the letter L, followed by my surname. 2 contacts in an autocomplete field. 1 careless keystroke. I read it standing up, still holding a flattened cereal box. Then I set the cereal box down, pulled out a kitchen chair, and read it a second time. Welcome back to Fierce Mom Stories. I am going to tell you exactly what happened, and I will let you decide the rest. Drop a comment and be sure to subscribe. I live on Herkimer Street in Hamilton, Ontario, in a house I bought in 1997 and paid off in 2018. I have a screen door that sticks in July and a radiator in the hallway that clangs once at 3 in the morning every February, which I have come to think of as a reminder that the house is still paying attention. There is a quilt on the spare bedroom door that belonged to my mother, sewn from her old house dresses and 2 of my father's flannel shirts. My grandchildren hide behind it when they visit. I have never taken it down. My name on the street is the woman with the garden, because I have a garden. My name at the Canada Revenue Agency, where I worked for 38 years, was Senior Team Leader. Individual Compliant Hamilton Tax Services Office, which is a longer way of saying that I spent nearly 4 decades determining whether people were telling the truth about their money. I know how to read a document. I know what an honest file looks like, and I know what a selected one looks like. I know the difference between an error and an arrangement. And I know, better than most people ever need to, what can be done with a social insurance number that doesn't belong to you. My daughter Leanne is 43. She coordinates projects for a consulting firm downtown and has never once filed a tax return late. I raised her that way. My son-in-law Drew Taggart is 44. He manages commercial leasing for a property development company and is not a dishonest man in the way that immediately comes to mind. He is the kind of man who decides something is fair and then works backward from that decision until it resembles logic. They built a house in Ancaster the year before last. 4 bedrooms, a great room, a mudroom, with built-in storage that nobody ever puts anything into. The construction came in $112,000 over estimate. Drew sat at my kitchen table in March and explained the numbers with the calm of a man who had practiced them. The construction loan, the appraisal delay, the carrying costs. He was not asking for anything, he said, in the voice people use when they are preparing to ask for something. I said I was sorry the build had gone over. He said he wasn't worried. He said it in a way that meant he was. I had been minding Jack and Ivy for 3 years by then. Jack was 7, Ivy was 4, and had speech therapy on Wednesday mornings at the clinic on Upper James with a woman named Dr. Ferris who wore colorful scarves and did not tolerate lateness. I knew the schedule better than anyone else in that house. I knew Jack's teacher by her first name and the name of her cat. I knew which brand of apple juice Ivy would drink and which one made her go quiet for half an hour in a way that was not peaceful. I brought things from my own kitchen. A good casserole dish. A set of measuring spoons Ivy liked to sort by size on the counter while I cooked, and an old stacking toy from when Leanne was small that Ivy found in my basement one afternoon, claimed immediately, and renamed Pip. I did not correct her on any of the names she gave things, because 4-year-olds should be allowed to name their own world. I never asked to be paid. I asked twice, in 3 years, to be told when they would be late, because Ivy has a particular kind of 6 o'clock meltdown that is much easier to manage if you see it coming and have the right stuffed elephant within arm's reach. Leanne texted me for a while. Then, sometime in the fall of last year, she stopped, the way things stop when no one formally decides to end them. I noticed, I documented nothing, but I noticed. The first time I heard the phrase was from Ivy, under the kitchen table, reaching for a dropped crayon. She said cheerfully, to no one in particular, "Grandma gets muddled." She was not being unkind. She was 4 years old and repeating something the way 4-year-olds repeat jingles and playground rhymes, without weight or intention. But I knew where she had heard it, and I have spent enough years in offices to know that a sentence said, near enough people, often enough, stops needing an adult to carry it. At Thanksgiving that year, Leanne's house, her good tablecloth, Drew's attempt at a honey-glazed ham that he is quietly proud of despite its inconsistency. A woman I had never met appeared at my elbow near the appetizer table. Her name was Darlene. She wore a good blazer in October in a way that suggested she'd come from somewhere with climate control and intended to return to it. She told me about her aunt in Burlington and the difficulty of waiting too long, and she spoke warmly and with what appeared to be genuine feeling. She handed Leanne a folder before she left, a folder she did not hand to me. Leanne slid it beneath her purse on the sideboard without opening it. The logo in the corner read ClearPath Senior Living Solutions, the tagline on the back, "The right time is before you think you're ready." I carried 2 plates to the kitchen and thought about what it means to build a business at the intersection of your own worst year and everyone else's. Here is what the email said. My son-in-law had been in contact with a law firm about the timeline for a capacity assessment. He referenced an application to the Ontario Superior Court of Justice, Estates Branch. He mentioned a document that would need updating with the most recent entries. And he noted, in a line toward the bottom, that he had written as a note to himself, or to my daughter, that the spring listing for Herkimer Street would benefit from having the estate questions resolved before March. Herkimer Street is my address. At the bottom of the email chain, in an earlier message, my daughter had written 4 words back to him. "Tell her it's just math." He had replied, "Working on it." I want to be honest about the 30 minutes after I read that email the second time. I put the laptop away. I went to the bedroom and sat on the edge of the bed, with my hands folded in my lap for a while, looking at the quilt on the spare bedroom door. I did not cry. I want to say that was composure. It was not. It was 38 years of practice, sitting still with information you are not yet ready to use. Then I got up, heated the soup, and met Jack and Ivy at the door at 5 o'clock, the same as any other Tuesday. I did not call Leanne. I have never once gotten anywhere by handing someone a chance to write a better version of the story before I understand the one they've already started. The first thing I needed was to know what they actually had. I did not rely on memory. That point matters, because memory was precisely what they were planning to attack. I called my family doctor's office the next morning and requested my complete records for the previous 12 months. I am the patient. I filled out the authorization correctly, specified the date range and record type, and asked for certified copies. If you have spent your career requesting documents from people who would prefer not to send them, the form is not the difficult part. 4 days later, a brown envelope arrived. Medical records are not only test results. They include every dated note a receptionist types when a phone rings. There was a note in mine. A Thursday in early September. My daughter had called. She had expressed concerns about my memory and asked to be added as an emergency contact on my file. She had also asked whether her concerns could be noted in my chart. The receptionist followed the rules correctly. Nothing was entered. Nothing was released. The call was documented with a timestamp. My daughter had called my doctor's office in September to establish a paper trail about my memory. 12 days later, I had a routine appointment that included a standard cognitive screen. I have mild arthritis in my right hand, and my doctor does a brief cognitive baseline for patients over 65 before any procedure involving sedation. I had an ultrasound-guided joint procedure booked for November. I'd known about the appointment since July. I completed the screen. I scored 28 out of 30, losing 2 points on delayed word recall, which has never once been relevant to anything I have done professionally or personally, and which I maintain is an unreasonable thing to ask a person to do before 9 in the morning. 12 days after my daughter called my doctor to ask whether her concern could become a record, my doctor made a record. It said 28 out of 30. I put the phone note in a folder and labeled it. Then I went looking for the financial piece, because there always is one. I have a My account with the CRA. I have always maintained one. I logged in and pulled my tax summary information for the previous 3 years. I was looking for something specific. I found it. Over 3 consecutive tax years, someone had claimed childcare expenses using my social insurance number as the registered service provider. My name, my SIN, my address on Herkimer Street, appearing on the T778 schedules attached to Drew Taggart's T1 returns. I had never issued a receipt. I had never submitted an invoice. I had never been asked to do either. I sat with that for a moment. Then I remembered a driveway in April, 18 months into the arrangement. Drew had come out to my car with a single sheet of paper and a pen. He said it was for his company's dependent care benefits file, routine paperwork. Could I sign where indicated and provide my SIN since I was listed as a care provider? It took perhaps 20 seconds. I handed the paper back and did not ask for a copy because he was my daughter's husband and I had just watched him carry Ivy on his shoulders from the house to my car in the rain. I had given a man my social insurance number on a driveway and thought nothing more of it for 18 months. I wrote 3 things on the back of my hydro bill: the date, the SIN, the total. Then I called Joan Pritchard's office on James Street North and asked for her first available appointment. Joan is 61 and has been my lawyer since the year I needed someone to handle my mother's estate. She does not fill silence unless she has something useful to put in it, which is the only quality I require in a person I am paying by the hour. She pulled my file before I finished sitting down. I had come to her office in the autumn of 2015, 8 months after my mother passed, after watching Leanne approach every financial detail of that estate with an efficiency that had nothing to do with grief. My mother had wanted one more winter in her own house. Leanne had the property assessed before the funeral lilies were brown. That November, I sat in Joan's office and completed everything. A will. A continuing power of attorney for property, naming my friend Bernice as my attorney, with my brother Murray as alternate. A power of attorney for personal care, the same designations. And one more document, because Joan asked me a question at the end of that appointment that no one had ever asked me before. She asked who I would not want. The document is a direction regarding guardianship, made under Ontario's Substitute Decisions Act. It states in advance, while a person has full capacity, who should and should not be considered for appointment as guardian of the person or property. I typed paragraph 3 myself on Joan's office computer because I did not want to say those sentences out loud to another person and have them written down by someone else's hand. My daughter, Leanne Taggart, shall not serve as my guardian of the person or guardian of property. Her spouse shall not serve in either capacity. I make this direction freely, with full capacity, on this date, and I ask that any court give it effect. Signed in November of 2015. 2 witnesses with no financial interest in my estate. Notarized. It had been sitting in a green hanging folder in my filing cabinet for 9 years, between my property tax history and my RRSP documentation, in a drawer labeled Legal. Personal, that I open perhaps twice a year. I had not thought about it once since I filed it. Joan read paragraph 3 twice. Then she looked up. She said I had written this myself. I said I had. She said she remembered the meeting. Then she told me what the document does, and, more importantly, what it does not do, and she did it in plain language, which is why I hired her. In Ontario, when a court considers guardianship, it does not simply appoint the nearest available relative. It weighs suitability and gives real consideration to any advance designation the person made while capable. If someone has been expressly excluded, The applicants must give the court a genuine reason to override that exclusion. They cannot simply ignore it. Then she set her pen down. "But hear me," she said. "This proves you had capacity in 2015 and that you made a considered decision. It does not prove you have capacity today. That is the fight. They will say you've changed." I told her about the cognitive screen. 28 out of 30, ordered for a scheduled procedure in November, booked since July, 5 months before anyone filed anything. Joan wrote that down. I told her about the phone note. September, my daughter calling the office, 12 days before the assessment. Joan wrote that down. Then I told her about the T-778 forms. 3 years of childcare expense claims on Drew's tax returns. My SIN, my name, my address. $9,860 in tax benefits over 3 years, reimbursed to my son-in-law for childcare I had provided at no charge. Joan was quiet for a moment. "How much?" I told her again. "Do you have documentation?" I had the CRA my account printouts. I had the date I gave him my SIN. I had already submitted a formal third-party information request through the CRA taxpayer relief process, naming myself as the service provider referenced in the returns, requesting every supporting document submitted bearing my identification number. Joan raised an eyebrow. I said I used to do this for a living. She nodded slowly. "Yes," she said, "I remember." I was served on a Wednesday morning in early November. A man in a rain jacket came to the door on Herkimer Street and said my name as a question. Behind him through the storm door, I could see the neighbor's maple gone to bare branches overnight. I signed for the envelope and took it inside. Application to the Ontario Superior Court of Justice. Estates Branch. Application for guardianship of the person and guardianship of property of Greta Ann Milburn. Petitioners, Leanne Taggart and Drew Taggart. Attached were exhibits. Exhibit A was 3 pages of background. Exhibit B was 17 pages, titled Observations and Concerns Record. G. Milburn, with a small ClearPath logo in the lower right corner. It was in my daughter's handwriting. 28 entries. Left column, date and description. Right column header, observed safety implications. I went to my desk and got a red pen, which I have kept in the 3rd drawer since 1986, and I started at entry 1. February 11, forgot Jack's dental appointment. Children waited at school. I had not forgotten. I had not been told. The appointment was made by Leanne in January, and she had mentioned it twice in the same conversation, both times saying Tuesday. The appointment was moved to a Thursday 3 days before it happened. I have the text from the dental office confirming the change, sent to the emergency contact on file, which was me. May 29, left rear burner on at Ancaster House, unattended, fire risk with children present. That was Leanne's stew on a Sunday at her own house. Jack told the story at dinner 2 weeks later without being asked. How Mum's pot went black and the smoke alarm went off and Dad waved a dish towel at the ceiling. Drew had looked at his plate. August 22, became confused at intersection of Garth and Rymal, required direction from Ivy. I stopped at that intersection because a construction detour had altered the lane markings since the previous week. I have a dash cam. The footage from that date shows the construction signage clearly. Ivy had pointed out the window and said, "There's a digger," which is not the same thing as providing navigational direction. I went through all 28 entries, 28 small events, each accurate in its outermost layer, each shaped by the hand that arranged them. In 38 years of compliance work, I reviewed a great many files that arrived with a conclusion already built in. The first thing you learn is that a file containing only unflattering information is not a complete file. It is a curated one. A chart with no contradicting entries has not been honest. It has been edited. Joan requested certified copies of everything from the appropriate custodians. From my doctor's office, the cognitive screen report with its full pre-procedure context and the phone note attached. From the CRA, and this required a formal request and 22 business days, the complete provider documentation submitted by Drew Taggart on his T-778 schedules for 3 consecutive tax years. Every claim form, every receipt. And in the provider certification box, on each receipt, in handwriting I recognized my name, my SIN, and a statement certifying that the named provider had delivered the childcare services as described. The certification was not in my handwriting. It was in my daughter's. She had certified, on government tax documents submitted to the Canada Revenue Agency, that I was a qualified and competent childcare provider capable of sole supervision of 2 minor children, 9 to 10 hours per day, 5 days per week. She had certified it most recently on a form dated 6 weeks before she walked into a courthouse and told a judge I could not manage my own affairs. I gave the full file to Joan and let her decide what belonged in front of a judge. The hearing was at the Hamilton Courthouse on a Thursday morning in November. I wore navy. I did my own hair. I arrived at 8:40. The gallery filled in ways that told me everything. Second row, Darlene from ClearPath in her good blazer, a leather portfolio on her knees. Behind her, a young man in a company polo holding a clipboard. I found out afterward what was on it. Third row. 2 women I recognized from Leanne's office, seated stiffly, not quite sure where to look. Back row, Bernice in a blazer with actual buttons, and my brother Murray, who had driven from Calgary and arrived the night before and was wearing a tie he had pressed incorrectly, but had pressed. Joan introduced herself as my retained counsel. The judge accepted that and moved forward. My son-in-law testified first. He said he had known me 11 years. He said the word concerned 4 times in the first 5 minutes. He said the family had not come to this decision lightly. He read from the observations record in a measured voice, the voice of a man who has decided in advance that he is the reasonable person in the room. The other side's lawyer asked why the urgency. Why apply for temporary guardianship now rather than wait? My son-in-law said there was a window for these things. He said that was what they had been told. He said it without appearing to hear what he had just said. Joan wrote 4 words on her notepad and slid it 2 inches toward me. He said it out loud. When she stood, she began with the cognitive screen. She explained the pre-procedure context in 3 sentences. She noted that it was ordered in July, 5 months before the application was filed, for a procedure I had scheduled myself, at my own initiative. She noted that I had scored 28 of 30. Then she picked up the phone note and read it into the record in full. My daughter had called Dr. Vandermeer's office on the 4th of September. She had expressed concerns and asked whether they could be entered into the chart. The receptionist had correctly documented the call and entered nothing. On the 14th of September, I completed the standard cognitive screen. On the 22nd of October, my daughter and son-in-law filed their application. The room was quiet in a way that said people were doing arithmetic. Then Joan handed the certified copy of the direction regarding guardianship to the judge and waited while he read. He read paragraph 3 out loud. He read it once, in the measured way judges read when they want every person in a room to hear the same words at the same time. My daughter, Leanne Taggart, shall not serve as my guardian of the person or guardian of property. Her spouse shall not serve in either capacity. My daughter made a sound I had not heard from her since she was 11 years old and had just been told something she could not argue around. The judge set his glasses on the bench and looked at me directly. He asked why I had written that document. I stood up. I do not raise my voice. I have not once needed to. I said, I wrote it 8 months after we buried my mother. I said my mother had wanted 1 more winter in her own home, and my daughter had the property assessed before the memorial service. I said I wrote it because I already understood at that point that there is a version of care that looks like love from the outside and feels like arithmetic from the inside. And I said I wrote it hoping I would die before anyone ever found out it existed. I looked at my daughter when I said the last part. She was sitting with her spine straight and her chin level, which is the posture she takes when she is recalculating. Joan laid the CRA documentation on the record last. She explained the T778 schedules in plain language, the 3 plan years, the provider certifications, the total tax benefit of $9,860 received by Drew Taggart for childcare I had provided without charge and without knowledge that any claim was being made. She looked at my son-in-law, who was still in the witness area. On the form dated 6 weeks before you filed this application, she said, "Your wife certified that this woman was capable of sole supervision of your children for 10 hours a day. You co-signed it. Which document would you like the court to disregard?" He did not answer immediately. The silence lasted long enough that Murray, behind me, shifted in his seat. Then my son-in-law said quietly to the table in front of him, "I didn't want it to go this way." My daughter came out of her chair without being called. She said I had been building a case against my own family for years. She said I had kept things hidden. She used a word about Joan that I will not repeat. The judge said her name once, the way you say a name when you mean stop now, completely, and she stopped. I sat with both hands resting on my purse. The dashcam footage had already been entered. The documents had already been entered. I said nothing for the remainder of the hearing, because when someone is making your argument for you, the kindest thing you can do is remain still. The judge took 14 minutes. He denied the application for temporary guardianship. He found no clear and convincing evidence of incapacity. He observed, in a dry tone, that the most compelling evidence of my functional competence had been submitted by the applicants themselves, under their own signatures, on government tax documents in triplicate to the Canada Revenue Agency. He found the direction regarding guardianship valid on its face and gave it the weight the Substitute Decisions Act provides. He stated that the applicants had offered no sufficient reason to override an express exclusion made by a capable adult. He awarded costs and a portion of my legal fees against them jointly and directed the clerk to transmit the CRA documentation to the appropriate regulatory bodies. Then he moved on to the next matter on his docket. Because it was 10:53 in the morning, and there were other people in the hall. Leanne found me by the water fountain on the way out of the building. She said, "So that's it, you just had all of that sitting there." I said I had had it for 9 years. She said, "Why didn't you ever tell me?" I had thought about that. The honest answer was the one I had been carrying since the November I walked into Joan's office. "Because telling you would have meant defending the decision," I said. "And I had a right to make it, without having to defend it to the person it concerned." She opened her mouth and did not finish the sentence. Behind her, Darlene from ClearPath was folding her clipboard materials in half, tucking them into her bag and moving toward the exit without making eye contact with anyone. I picked up my purse. I said the only thing I had prepared. "You are my daughter. I am not a file you get to manage." Both of those things are true at the same time, and they are going to have to stay true at the same time. Then I walked to where Murray and Bernice were waiting by the elevator, and we went to find somewhere that served decent coffee. The CRA opened a compliance review into the T-778 claims within 3 weeks of the hearing. Drew was required to repay the tax benefits with assessed interest. A separate examination was opened into the manner in which the provider identification had been obtained and used. He kept his position at the company. I was glad about that, in a way I do not expect to have to justify to anyone. Herkimer Street is still mine. My property tax bill arrived in January and I paid it the same day, as I have every year since 1997. Joan filed an updated direction regarding guardianship in February, re-executed, re-notarized, with one new clause specifying that anyone acting at the direction of the excluded persons is similarly excluded. A certified copy went to the court registrar. A certified copy went to Dr. Vandermeer's office. I gave one to Bernice in person over tea. I sent one to Leanne by registered mail. She signed for it on a Tuesday. I have the delivery confirmation in the green folder, behind paragraph 3, where it belongs. Some Sundays, Leanne drops Jack and Ivy at the curb and does not come up the walk. Some Sundays, she comes to the door. We have not spoken directly about what happened. I do not know if we will, or when. I am not waiting on it, and that is not coldness. It is simply an honest accounting of how long certain things take. The quilt still hangs on the spare bedroom door. Ivy hid behind it in March and stood very still while Jack narrated her location to me in real time from across the hallway. I searched the kitchen first, then the bathroom, then came slowly down the hall. I passed the quilt twice. On the third pass, one of Ivy's socks appeared beneath the hem. I said, "I cannot find her anywhere. I have looked everywhere. She must have vanished." Ivy burst out from behind the quilt and announced that she had won. I told her she was very good at hiding. She already knows this, but it is still worth saying. If you are listening to this while you are doing something ordinary, folding laundry, washing dishes, sitting in a parking lot waiting for someone, I want to ask you one thing before you close this. Write down the name of the person you would want speaking for you if you could not speak. Then, write down whether there is someone you would not want. Do it this week, not someday, not when things feel urgent. Do it now, while the decision is entirely yours, and no one is watching and nothing is at stake. The paperwork you do calmly in the quiet years is the only paperwork that cannot be rearranged later. I know this because I spent 38 years rearranging other people's. And I know it because I found mine in a filing cabinet on an otherwise ordinary evening, 9 years after I put it there, and it was the only thing I had done in my entire professional life that I was glad had no expiry date. Name your person. Name the one you don't want. Do it while your signature is still entirely your own. Drop a comment if this made you think about something you've been putting off. Subscribe, and I'll see you next time.